In this lecture, we shall discuss the effects and the consequence of not complying with the High Court's Civil Procedure Rules 2004 CI 47. The consequence of not complying with the High Court Civil Procedure Rules 2004 CI 47. Now, for anybody that has a fair idea about these rules that we refer to as the High Court Civil Procedure Rules 2004 CI 47, you will notice that these are rules that govern proceedings in the High Courts and the Circuit Courts in Ghana. So that if you file a case before the courts in Ghana, you commence an action before the courts in Ghana, all the courts have their own rules that they apply. And the rules applicable to the High Courts and the Circuit Courts, they are the rules that we refer to as the High Courts Civil Procedure Rules 2004 CI 47. Now, the authority for saying that it applies to both the High Courts and the Circuit Courts is clearly embodied in Order 1 of the High Court Civil Procedure Rules. So, Order 1 of the High Court Civil Procedure Rules 2004 CI 47, it reads as follows, and I quote, "These rules shall apply to all civil proceedings in the High Court and the Circuit Court, except that the application by the Circuit Court shall be with such modifications as may be necessary. These rules shall apply to all proceedings, all civil proceedings in the High Court and the Circuit Court, except that the application by the Circuit Court shall be with such modifications as may be necessary." What do we mean by this? What we mean is that the rules will be applicable only in respect of civil proceedings. And it's going to be applicable in respect of civil proceedings in the High Court and also in the Circuit Court. But if you're applying it to the Circuit Court, it shall be with such modifications as may be necessary. Because you see, there are some provisions in the CI 47 that are reserved exclusively for the High Court. For example, you know, under Article 33 of the Constitution, it's only the High Court that has exclusive original jurisdiction in matters relating to the enforcement of fundamental human rights. Therefore, under Order 67 of the CI 47, there are rules that have been provided inside to deal with civil proceedings that relate to enforcing fundamental human rights. We have a full order, Order 67, that is dealing with enforcing fundamental human rights in the CI 47. So if you've seen Order 67 in the CI 47 dealing with fundamental human rights, it doesn't mean that you can go to the Circuit Court to enforce human rights. In other words, there are some provisions in the CI 47 that would only be applicable to the High Court. So when you're applying to the Circuit Court, it shall apply with the necessary modifications as may be necessary. But that is a different topic to be discussed. What is important to be discussed in this lecture is this: that Order 1 says the rule shall apply to all civil proceedings in the High Court and the Circuit Court. Now my question is, what happens when you take a proceeding, you take a step in a civil action in the High Court, but you fail to comply with the provisions that have been set out in these rules? What should be the effect of not complying with the provisions in the CI 47? Assuming the rules have provided that you must do something before following the process, and you fail to comply with it, what is supposed to be the consequence of failing to comply with the provisions set out in the rules? Should it render the proceedings void because the lawmakers have provided for some rules and you have decided to disobey it? And if it doesn't make it void, then it means that what is the effect of the rules at all? If everything that you do can be cured, what should be the essence of the rules therefore? That is what we seek to discuss in this lecture. We want to interrogate the effects of not complying with the rules of the CI 47. Now, what is instructive for us to note is that the answer to this question has been provided for under Order 81 of the CI 47. Order 81 of the CI 47 provides as follows, and I read. Non-compliance with rules not to render proceedings void. Non-compliance with rules not to render proceedings void. It says that where in beginning or purporting to begin any proceedings or at any stage in the course of or in connection with any proceedings, there has, by reason of anything left undone, been a failure to comply with the requirements of these rules, whether in respect of time, place, manner, form, or content, or in any other respect, the failure shall be treated as an irregularity and shall not nullify the proceedings. Any step taken in the proceedings or any document, judgment, or order in it. I'll explain this provision briefly and I'll proceed to deal with the background and I'll have to return to revisit this. Let's take a critical look at the wording of Order 81. Let's even look at the heading. It says non-compliance with rules not to render proceedings void. In other words, if anybody fails to comply with these rules, the effect of failing to comply with the rules should not render the proceedings void. And take a critical look at the wording of the order. It says that where in beginning, even in beginning, where in beginning or purporting to begin. So, meaning that even if you are beginning or you are purporting to begin or at any stage in the proceedings, so either at the beginning or purporting to begin or at any stage at all in the proceedings, there has, by reason of anything left undone, there's something that you haven't done, and it is a failure to comply with the requirements of the rules. That is a very important provision. It says, being a failure to comply with the rules, whether in respect of time. So, in other words, if you fail to comply with the rules in respect of time, if you fail to comply with the rules in respect of place, if you fail to comply with the rules in respect of manner, if you fail to comply with the rules in respect of form, or if you fail to comply with the rules in respect of content. So, the lawmaker hasn't just mentioned non-compliance with the rules. It says that where there has been anything done or left undone, being a failure to comply with the requirements of these rules, and then failure to comply whether it is in respect of time. So let's say the rules has given timeline to do something, and you have failed to comply with that time. So whether in respect of time, whether in respect of place. So for example, the rule says that you must file this at this particular venue. So whether in respect of place, you have failed to comply with the rules in respect of place, or you have failed to comply with the rules in respect of manner, or you have failed to comply with the rules in respect of form or content. So you see, it mentions time, place, manner, form or content, and it didn't end there. And it asks, or in any other respect. So you see, it says, when you fail to comply with the rules, whether in respect of time, in respect of place, in respect of manner, form or content, or in any other respect, that failure shall be treated as an irregularity, and it shall not nullify the proceedings. Any step taken in the proceedings, or any document, judgment, or order in it. Order 81 is telling you that if there's anything left undone or done, which is a failure to comply with the rules, whether it is in respect of time, place, manner, form or content, or in any other respect, that failure shall be treated as an irregularity. And the effect is that it says it shall not nullify the proceedings. It shall not nullify any step to taken in the proceedings, or any judgment or document or order in it. Let's have an overview of this, and I'll return to revisit this. At least have at the back of your mind that Order 1 says that the CI 47 applies to the High Court. Have at the back of your mind that Order 81 says that if you fail to comply with the rules, whether it is in respect of time, whether it is in respect of place or manner, form or content, or in any other respect, the failure shall be treated as an irregularity, and it shall not nullify the proceedings. So have these at the back of your mind, and I'll return to revisit it. I have to proceed from this point because you are aware that the CI 47 was passed in 2004. But before the CI 47, we had other rules that were applying. So I want to now proceed to look at the trajectory. Let's go to the historical background. Let's look at the rules that were applicable before the CI 47 came. And let us see how those rules treated non-compliance with the rules. Because for some of the cases you'll be reading, they'll be referring to all those old cases. All those cases that were before 2004, they were dealt with under the old rules, or LN 140. So I'll have to go back to the history, look at the rules that were applicable before the CI 47, so that when you read those cases, like Azinogo and Augustt, when you read those cases, you would understand why some positions were taken in those cases. So let's proceed and look at Order 70 of LN 140. This is what we had in those rules. And I quote, "Non-compliance with any of these rules or with any rule of practice for the time being in force shall not render any proceedings void unless the court or judge so directs. But such proceedings may be set aside, either wholly or in part, as irregular or amended, or otherwise dealt with in such manner and upon such terms as the court or judge shall think fit." End of quote. Now what does this mean? I'll take a second read and a third read in order to emphasize something I have to draw your attention to. And I'm doing this because you'll be reading some cases. And those cases were decided before the CI 47. And you'll be wondering why the court took some positions. I need to let you know the background to those decisions. So I'm reading Order 70 Rule 1 once again. Non-compliance with any of these rules or with any rule of practice for the time being in force shall not render any proceedings void unless the court or a judge shall so direct. It means that under the old rules, the judge or the court is given the permission and the right to declare a proceedings void when there's a non-compliance with the rules. So the effect of Order 70 Rule 1 of LN 140, which is the rules that we are applying before the coming into force of the CI 47 in 2004. The effect of this Order 70 Rule 1 is that in the event that there's any non-compliance with the rules that are supposed to apply to the High Court, when there's any non-compliance with the rules, the judge has a discretion to either declare any proceeding emanating from such a breach as void. So under the old rules, the judge is given the power to exercise his discretion to determine whether if he fails to comply with the rules, he can determine and declare the proceedings as void. Because what it says, non-compliance with any of these rules or with any rule of practice for the time being in force shall not render any proceedings void unless the court or a judge shall so direct. Meaning that the judge has been given the discretion to declare that when you fail to comply with the rules, we shall declare the non-compliance as being occasioning a void proceeding. The judge is also given the discretion to save part or whole of the proceedings emanating from such a breach of the rules. So the judge also has another discretion that, okay, you have breached these rules. I'm going to save only this part of the proceedings. Let's say, for example, I'm saving the issuance of the writs all the way up to close of pleadings. But from application to directions to the end, I'm nullifying everything. The judge was given that power. That he can either save part or whole of the proceedings emanating from such a breach of the rules of the court on such terms as the judge may deem fit. So the effect of LN 140, the old rules that were applied before the CI 47, is that when there's any non-compliance with the rules, the judge has the discretion to declare any proceeding emanating from such a breach as void. Or he can also save the whole or any part of the proceedings emanating from that kind of breach. But the real question to be resolved is this. Now we know that under LN 140, the judge has the discretion to determine whether to declare the proceedings as void or not. But what were the principles that would guide the court's discretion? In other words, well, we agreed as well now the judge has the discretion. But what should be the guiding principles? What should guide the court in determining whether they will go ahead and set aside a proceedings as being null and void, or whether they are going to save the proceedings from being void? It's a very critical question. Because if you say that the judge can declare it as void, what should guide the exercise of such a discretion? And with this, when we review the case law would let us realize that there were two kinds of non-compliance under the old rules, that is the LN 140 and under 70. One category of non-compliance were the ones which would give the judge the permission to nullify the whole proceedings. And there were some other kinds of non-compliance that will not render the proceedings a nullity. Because if you look at the wording, it says that shall not render any proceedings void unless the court or the judge so directs. But such proceedings may be set aside either wholly or in part as irregular or amended. So there are some proceedings that if we realize, we can treat those non-compliance as a nullity. So the non-compliance will render the whole proceedings a nullity. And there were some other non-compliance that will not render the proceedings a nullity. Because as we saw the effect of the Order 70 is that there were some proceedings that if you fail to comply with Order 70 of LN 140, would render the whole proceedings as null and void. And there were some other non-compliance that if you fail to comply with the rules, it will render the proceedings null and void. But the court will have the discretion to save the proceedings from being set aside as being null and void. So from the case law that we will review, there will be two categories of non-compliance. One category will be non-compliance that will render the whole proceedings a nullity, and there will be non-compliance that will not render the proceedings a nullity. But the real question that has not been answered is this. How do the courts differentiate between non-compliance which will render the proceedings void and those non-compliance which will not render the proceedings void? So how do we identify the non-compliance that will render the proceedings void and those that will not render the proceedings void? The words of Taylor JSC in Amoakoh and Hansen. Amoakoh is spelled A, M for mango, O for orange, A for antelope, K for king, O for orange, and H for hospital. So Amoakoh, A-M-O-A-K-O-H, Amoakoh versus Hansen. Hansen is spelled H-A-N-S-E-N, N for nice. So Amoakoh and Hansen is reported in 1987 to 1988 two Ghana law reports, page 26, specifically at page 37. Taylor JSC, this is what he said. And please have the background of what he's about to say. He's about to tell us what should guide the court in determining whether a non-compliance will render the proceedings void and the one that will not render the proceedings as void. This is what Taylor JSC said, and I quote. Remember, I'm quoting Taylor JSC in Amoakoh versus Hansen, reported in 1987, 1988, two Ghana law reports at page 26. Specifically, the words I'm about to quote are from page 37 of the report. And these are the words of Taylor JSC, and I quote. If, however, it is an irregularity that goes to the roots of the trial and fouls the springs of the judicial process, and thus disabling the machinery of law from advancing the cause of justice, then the whole proceedings is void and nullity. Again, if, however, it is an irregularity that goes to the roots of the trial and fouls the springs of the judicial process, and thus disabling the machinery of law from advancing the cause of justice, then the whole proceeding is void and nullity. What is Taylor JSC saying over here? End of quote. What is he saying over here? He's saying that if it's an irregularity that goes to the root of the trial, and is an irregularity that fouls the springs of the judicial process, and is an irregularity that disables the machinery of law from advancing the cause of justice, then the whole proceeding will be void and it will be a nullity. That is what Taylor JSC is saying. If it's an irregularity that goes to the roots of the trial, meaning it's going to the very foundation of the trial, going to the very bottom, meaning that this irregularity, it is rendering the whole proceedings dead on arrival. It is rendering it incurably defective. Taylor is saying, if it's an irregularity that goes to the roots of the trial, and it fouls the springs of the judicial process, and thus it disables the machinery of law from advancing the cause of justice, then the whole proceeding is void and a nullity. These are the words of Taylor JSC in Amoakoh versus Hansen. Amoakoh versus Hansen, reported in 1987, 1988, two Ghana law reports at page 26. So take note of what Taylor JSC has said. That an irregularity that goes to the root of the trial and fouls the springs of the judicial process and disables the machinery of law from advancing the cause of justice, then the whole proceeding will be void and a nullity. Remember, we had mentioned that there were two types of non-compliance under the old rules. We mentioned that we have one category of non-compliance, that if you fail to comply with the rules, it will render the whole proceedings a nullity. And there's another type of non-compliance that it will not render the proceedings a nullity. And so we're asking ourselves, how will the court determine the kind of non-compliance that will render the proceedings void? Taylor is telling us that if it's a non-compliance and it's an irregularity that goes to the root of the trial and disables the machinery of law from advancing the cause of justice, then the whole proceedings will be void. So we now have one of our answers. We have our answer to how the court will determine the kind of non-compliance that will render the whole proceedings a nullity. And that is Taylor JSC in Amoakoh versus Hansen. Another case is very important, and that case is Bonsu versus Eyifa and another. Bonsu is spelled B-O-N-S-U versus Eyifa. Eyifa is E-Y-I-F-A-H and another. Reported in 2001, 2002, one Ghana law report at page 9. I'm going to read the words of Apal J, as he then was, specifically from pages 16 to 17 of the report. Bonsu versus Eyifa and another. And this is what Apal said in this case, and I quote, I have to state the points clearly. that the only irregularities that can be cured by Order 70 of LN 140A are those that border on the non-compliance with the rules of courts or any rules of practice. But even then, it is not in cases for where the courts think that injustice will be caused to the other party when a rectification is allowed, the court shall decide otherwise. However, where the irregularity is a non-compliance with the rules, but where the irregularity is not a non-compliance with the rules of courts, but borders on non-compliance with the requirements of a statute or other authority, then the whole action becomes a nullity. So, Apauge in Bozo and Eifa is also trying to give some assistance to show the kinds of non-compliance that will render the proceedings void and the ones which will not render the proceedings void under the old rules, which is the LN 140. He was telling us some kinds of non-compliance that can be cured and the ones that cannot be cured. So far, I have referred to the case of Amoakoh and Hansen, reported in 1987, 1988, and I've referred also to the case of Bonsu and Eifa. So, at least, at this point, we realize that under the old rules, LN 140, there were some categories of non-compliance that will render the proceedings void. And again, there could be some non-compliance too that will not render the proceedings void. So it means that we must take critical look at the old rules. That is the LN 140. I want us to take a critical look at this case, which was still decided under the old rules, which is the case of Azinogo. Azinogo is spelled A-Z. Azinogo is spelled A-Z-I-N-O-G-O versus Augustt. Augustt is spelled A-U-G-U-S-T-T and Company Limited. This case is reported in 1989, 1992 Ghana Law Reports, specifically at page 278-282. Please, I'm going to go through the facts and the material portions of this case to let you know the kind of non-compliance that happened in this case. And let us see the consequence of that non-compliance. I'm reading from the case itself. And I quote, "It is provided by Order 14, Rule 23 of the High Court Civil Procedure Rules 1954, LN 140A, that the summons, a copy of the affidavits in support, and of any exhibits referred to therein must be served on the defendant not less than 4 clear days before the return day. The defendant was served with the motion for judgment on 1st December 1987. And on 4th December, when still no defense had been filed, the High Court gave summary judgment for the plaintiff. The defendant appealed against that judgment." Let me explain this before I move ahead. By the rules, the applicant here is applying for what under the old rules we refer to as summary judgments. Then under the rules, if you're applying for summary judgment, if you serve the application on the person today, and let's say the day in question is 1st December 1987, by the rules, there must be not less than 4 clear days before the return day. So when you serve it on 1st, between the 1st and then the date on which you go to court, there must be at least 4 clear days before you go to court to go and move your application for the summary judgment. So if I serve you with the application today on 1st December, the rule says there must be at least 4 clear days before the return day you will go to court and move your application. From the facts, we are told that the defendant was served with the motion on 1st December 1987. So on 1st December 1987, it means 2nd will be 1st day, 3rd December will be 2nd day, 4th December will be 3rd day. But they rather went to court on the 4th of December, meaning that we didn't have the 4 clear days before they went to move the application. So I'm reading still from the head notes. The defendant was served with the motion for judgment on 1st December 1987. And on 4th December, when still no defense had been filed, the High Court gave summary judgment for the plaintiff. The defendant appealed against the judgments. What do you think would happen? Because in this case, the rules say that you must give the person 4 clear days. You gave the person only about 3 days. It wasn't up to the 4 days. And you've gone ahead to go and take summary judgments. So there has been a non-compliance with the rules with respect to time. My question is, should this non-compliance render the whole proceedings void, or should it render it as void? Let us see what the court held. The court held that clear days had been construed to exclude the date from which the period commenced and the day when the act was done from the computation of the period of the notice period. In other words, the date on which a particular process was actually served and the date on which the thing was to be done should not be counted as part of the clear days required for the thing to be done. Let me interpret this. When the rule says 4 clear days, what they are saying is that you filed and served the application on 1st of December. We will not count that 1st of December. If you are going to court on the 4th of December, we will not count that 4th December. There must be at least 4 clear days interval between. So ordinarily, if you go by this, it means that if you serve the person on the 1st of December, then it means that 2nd December will be the first clear day. 3rd December will be 2nd clear day. 4th December will be the 3rd clear day. And then 5th December will be the 4th clear day. It means that if you serve them on the 1st, they must have at least from 2nd, 3rd, 4th, and 5th, 4 clear days. And the earliest you can go to court to move your application is supposed to be the 6th. Because there must be at least 4 clear days between the date on which you serve and the date on which the application is going to be moved. I'm proceeding to read the holding of the courts when the defendants appeal. At appellate court, it was held that in the instant case, since the motion for summary judgment was actually served on defendant on 1st December 1987, although it had been filed on 27th November 1987, the defendant did not have 4 clear days as required by Order 14 Rule 2.3 of LN 140. The defendant only had 2 clear days before the return date. The non-observance of the mandatory provision in Order 14 Rule 2 Sub Rule 3 was not merely irregular but void, and the defendant was entitled ex debito justitiae to have the judgment set aside. Again, in the instant case, since the motion for summary judgment was actually served on defendant on 1st December 1987, although it had been filed on 27th November 1987, the defendant did not have 4 clear days as required by Order 14 Rule 2, Sub Rule 3 of the High Court Civil Procedure Rules 2, 1954, LN 140. The defendant only had 2 clear days before the return date. Now we are coming to the non-compliance. The non-observance of the mandatory provision in Order 14 Rule 2 Sub Rule 3 was not merely irregular, but was void, and the defendant was entitled ex debito justitiae to have the judgment set aside. End of quote. What do we get from this case, Azinogo and Augustt? Remember, this is Azinogo and Augustt, reported in 1989-1990. Two Ghana law reports at page 278. Azinogo and Augustt. The court is telling us that by the rules, you are supposed to have given the person 4 clear days before you go and move your application for summary judgment. You gave them only 2 clear days. And the court is saying that that failure, that disobedience of the rules, its consequence was that it renders the whole proceedings void. And the defendant was entitled ex debito justitiae as of right to have the judgment set aside. When the rules require that you must give 4 clear days, you are going to give 2 clear days, Azinogo and Augustt. The court is saying that that failure, that non-compliance with the rules, it rendered the whole proceedings void. That it was not merely irregular, it was void, and it rendered the whole proceedings void. And so the defendant was entitled ex debito justitiae to have the judgment set aside. So never forget this case of Azinogo and Augustt, because I'll revisit it. Azinogo and Augustt. The rules say give 4 clear days, and you gave 2 clear days. The court said that non-compliance renders the whole proceedings void. So we've seen this case, and please remember this case. Do not forget it. We'll have to revisit it. Because we will have to get to the point where we must compare what was happening under LN 140 with what is happening currently under CI 47. So remember Azinogo and Augustt, that non-compliance with the rules with respect to time, when you're supposed to give 4 clear days and you give 2 days, the court treated this as a void process. And therefore, everything that transpired thereafter, the court said that you can set aside everything as void. There's another case that I'll let us discuss, which is the case of Amoakoh versus Hansen. In that case, Amoakoh and Hansen, a party failed to apply for what you call application for directions. But the case still proceeded. Let us see what will be the consequence of failing to take directions in the case. Will it be treated as a mere irregularity that can be cured, or the failure to take directions will render the whole proceedings null and void? Remember, Azinogo and Augustt, non-compliance with respect to time rendered the whole proceedings void. Let us see Amoakoh and Hansen and see what the non-compliance was and how the court treated that non-compliance. I'm reading from Amoakoh and Hansen. And Amoakoh and Hansen is reported in 1987, 1988, 2 Ghana law reports at page 26, specifically at page 37. And this is what transpired in Amoakoh and Hansen. And I'm quoting from the headnotes. I'm quoting from page 37 of the report. And I quote: before the enactment of the High Court's Civil Procedure Rules 1954, under 30, the courts in the country, even in the absence of pleadings, faithful to the adversary common law system of jurisprudence, had always insisted on the process of identifying the issues in the suits before the commencement of trial. And where there had been a failure to do that, the trial had been set aside. Order 30 had made the summons for directions concept a mandatory statutory procedure for formulating issues for trial in an action founded on pleadings. It was clear from the language of duty. It was clear from the language of duty was clearly cast on the courts to consider all matters raised on the summons and the stages at which the said matters were to be dealt with. And this is where the bomb lands. And I'm quoting from Amoakoh and Hansen, reported in 1987, 1988, 2 Ghana law reports, page 26, specifically at page 37. This is where the bomb lands, and I'm quoting at page 37. Since the High Court failed to hear the summons for directions, and thereby failed in its duty of ascertaining before the trial the issues on which the settlement of the matters in controversy between the parties depended, the hearing of the case was premature, and consequently, the judgment would be set aside. End of quote. Under LN 140, of course, when pleadings have closed, you have to apply for directions, summons for directions. The judge will have to hear the directions and set out the issues for trial. A tenor in this case, the summons for directions wasn't heard. But the case transpired, evidence was called, everything was done, and judgment was eventually given. Now someone has brought that issue up about failing to comply with the rules. Now that 13 requires that you must apply for directions and the court must hear it. Even though you've taken evidence and everything has been done and you've given judgment, you are saying that because you failed to apply for directions, what issues were the court even dealing with? They had failed to comply with a mandatory step. And the court said that that failure to comply with that directions, the application for directions, it was something that rendered the whole hearing premature, and consequently, the judgment will be set aside. And I think I can understand why the court took this position. Because it is at the application for direction stage that we set out the issues for trial. Right from first day in law school, we know for every case, there has to be issues for trial. So if you didn't hear the application for directions, what were the issues that you were even using to even read? So what were the issues you even resolved to even deliver the judgment? Because right from day one in law school, we are told that if you are briefing the case, you have to have your facts, you have your procedural background, you have your issues, and after every issue, you have the holdings. So if you didn't hear the application for directions, which will enable you set out the issues for trial, what issues did you even use as a basis to proceed with the case? That is why the court held that since the High Court failed to hear the summons for directions, and thereby failed in its duty of ascertaining before the trial the issues on which the settlement of the matters in controversy between the parties depended, the hearing of the case was premature, and consequently, the judgment would be set aside. So at this point, I have taken you through a number of cases. We've gone through a number of cases, and they all give us an indication as to what the effect of the LN 140 is. Remember, we've gone through Amoakoh and Hansen, where Taylor JSC said that if it's an irregularity that goes to the root of the trial, to render the whole proceedings as void. Remember what Taylor JSC said in Amoakoh and Hansen, that if there's an irregularity that goes to the root of the trial and fouls the springs of judicial process, and that disables the machinery of law, then it will render the proceedings void. That is Taylor in Amoakoh and Hansen. Remember also the case of Azinogo and Augustt, where we're told that you failing to comply with the timelines that you were supposed to give 4 clear days before you had your summary judgment, but you gave 2 clear days. The failure to comply with the time, we are told that it rendered the whole proceedings a nullity. Remember that one as well, Azinogo and Augustt. So remember Taylor JSC in Amoakoh and Hansen, and remember also the case of Azinogo and Augustt. Azinogo and Augustt is the one that says that summary judgment, if you are supposed to give 4 clear days and you give 2 days, it will render the proceedings a nullity. And Amoakoh and Hansen is a case also in respect of which the parties failed to apply for directions. And the court held that that failure was something that went to the roots of the matter, and it rendered the whole proceedings as null and void. And I've told you why, because the directions is where you set out the issues for trial. So if you didn't have the issues, when you're going ahead, what did you then use as a basis to now proceed? Amoakoh and Hansen. Remember Taylor JSC. Since the High Court there failed to hear the summons for directions, then the whole proceedings will be void and can be set aside. So at least from the old rules, that is the LN 140, there's something that we understand from there. That there were some proceedings that can be declared as a nullity, and some too will not be declared as a nullity. So the judge has a discretion to determine what he's going to describe as a non-compliance with the rules that he will say render the proceedings void, and the ones that he will say will not render the proceedings void. And so the implication of the law under LN 140 under 70, which is the background to the order 81, is that we know that there are some categories of non-compliance with the rules that will render the proceedings a nullity, as we've seen in Amoakoh and Hansen, as we've seen in Azinogo and Augustt. You remember in Azinogo and Augustt, you remember what transpired? In Azinogo and Augustt, you were supposed to give 2 clear days, but you were supposed to give 4 clear days, and you went to give 2 clear days. The court said that non-compliance will render the proceedings a nullity. That is Azinogo and Augustt. So that was a non-compliance with respect to time. The court held that it will render the proceedings a nullity, and the defendants will have the chance to have everything set aside, ex debito justitiae. Then you come to Amoakoh and Hansen. You failed to apply for directions. The directions wasn't heard, but you proceeded to hear the case. You took evidence. Taylor GSE is saying that there are some categories of non-compliance that they go to the root of the matter and they foul the springs of the judicial process. When it happens that way, we'll say that the proceedings will render a nullity. So what I want you to notice is that these 2 cases were all non-compliance with the rules and not statutes. They were non-compliance with the rules itself of the LN 140. Amoakoh and Hansen, non-compliance with the rules. You failed to apply for directions. Azinogo and Augustt, non-compliance with the rules. You were supposed to give 4 clear days, and you gave 2 clear days. So at least, what we know under the old rules are that the judge has a discretion to determine what proceedings he can set aside as a nullity, and the ones that he will not set aside as a nullity. And everything, the discretion, will be guided by the facts of the case. It will be guided by the understanding of the judge as to what the justice of the case demanded. So the judge has the discretion, if you fail to comply with the rules, to determine what non-compliance will render the proceedings void, and the one that will not render the proceedings void. That is LN 140. So this is by way of background, because these are the rules that we applied before we had the CI 47. And by way of summary, what you know under the old rules are that there were some categories of non-compliance that will render the proceedings a nullity. And there were some too that will not render the proceedings a nullity. Because as you will see, we've seen in Azinogo and Augustt that when you fail to comply with the rules in respect of time, that's one alone, the court held that it will render the proceedings a nullity. We've seen in Amoakoh and Hansen, when you fail to comply with the rules by not applying for directions, it will render the proceedings to a nullity. But like I said, there are some kinds of non-compliance that will not render the proceedings a nullity. And before I proceed, let's have a look at the case of Amoakoh. Amoakoh is spelled A-M, M for mango, E-Y-I-B-O-R. Amoakoh versus Komla. Komla is spelled K-O-M-L-A. Reported in 1980, Ghana Law Reports at page 820, specifically at page 825. This is what was said in that case, and I quote, "The failure by the bailiff to make the endorsement required by the rule resulted in no injury or prejudice to the defendant. The learned judge ought not to have treated the irregularity as a nullity and proceeded to dispose of the matter on that basis. He should have brought the failure to make the endorsement required as an irregularity and done justice as a matter of discretion between the parties." This case is telling us that there's still a non-compliance with the rules here. But the court is saying that this non-compliance, it didn't result in any injury or prejudice to the defendant. So because it didn't result in any injury or prejudice to the defendant, it will be an irregularity. And then if it's an irregularity, then the court shouldn't have treated it as a nullity to nullify the whole proceedings. That they should have just treated it as a mere irregularity, so that it can be cured. So they said that the learned judge ought not to have treated the irregularity as a nullity So you see, in this case, there's still a non-compliance with the rules. By this time, the judge has looked at the entire facts and the circumstances and the justice of the case, and he's saying that this irregularity, it didn't cause any injustice to the other party, so it's not supposed to render the whole proceedings a nullity. Amoakoh versus Komla. So at this point, I want us to just summarize what we know under LN 140, which is the rules that were applicable before the CI 47. We know that under LN 140, there were some categories of non-compliance that when you fail to comply with the rules, it will render the proceedings a nullity. Like we have seen in Amoakoh and Hansen, when the parties fail to apply for directions. The court tailored GSC that there are some irregularities that go to the root of the matter that will render everything a nullity. We saw it in Amoakoh and Hansen, that there was an irregularity that rendered the whole proceedings a nullity. We saw it too in Azinogo and Augustt, when the rules require that you must give 4 clear days, and you gave only 2 clear days. The court held that it rendered the whole proceedings a nullity. But we've seen in Amoakoh and Komla that failure by the bailiff to make the endorsement required by the rule, it didn't result in any injury to the defendant. Therefore, that non-compliance ought not to have been treated as an irregularity. It ought to have been cured. So at least what we have at this point is that under the old rules, at least we are certain that there are some kinds of non-compliance that can render the whole proceedings a nullity. And there are some non-compliance that cannot render the proceedings a nullity. But the exercise of the discretion will depend on the judge. The judge is the one that will look at the entire facts, as he looked at in Amoakoh and Hansen, and held that failure to apply for directions will render the proceedings a nullity. And the judge also looked at the entire fact in Azinogo and Augustt, that you were supposed to give 4 days, you gave only 2 clear days. Even though it was a non-compliance with time, they look at the facts and they said that this one, it should be a nullity. And then they rendered the whole proceedings void. So remember Amoakoh and Hansen, failure to apply for directions, rendered the proceedings a nullity. Remember Azinogo and Augustt, failure to give 4 clear days, rendered the proceedings a nullity. And remember Amoakoh and Komla, where the court held that there could be some non-compliance that could be cured by the rules. So by way of summary, under the old rules, there were some non-compliance that can be treated as a nullity, and others too will not be treated as a nullity. But everything will depend on the fact of the case and the understanding of the judge as to what the justice of the case demanded. Let us come to the new era of Order 81. Order 81 is the current provision that deals with non-compliance with our rules. And let us see how Order 81 will treat non-compliance with the rules. Will Order 81 say that if you fail to comply with the CI 47, it will render the proceedings null and void? Or it will not render it as null and void? Because remember, we've seen in Azinogo and Augustt that failure to comply with the rules with respect to time render the proceedings as void. We've seen also in Amoakoh and Hansen that failure to comply with the rules with respect to applying for directions render the proceedings as void. Order 81 is the current rules under the CI 47 2004, High Court Civil Procedure Rules 2004. How does it treat non-compliance? And I have it here to read. It reads as follows. Non-compliance with rules not to render proceedings void. Where in beginning or purporting to begin any proceedings, or at any stage in the course of or in connection with any proceedings, there has, by reason of anything done or left undone, been a failure to comply with the requirements of these rules, whether in respect of time, place, manner, form, or content, or in any other respect, the failure shall be treated as an irregularity and shall not nullify the proceedings, any step taken in the proceedings, or any document, judgment, or order in it. What do we get from Order 81 over here? Order 81, even the heading is even giving us a warning that non-compliance with the rules should not render the proceedings as void. We have even been given a warning from the beginning. Then it goes ahead, where in the beginning, or purporting to begin any proceedings, not even at the beginning alone, or at any stage of the proceedings. And it goes ahead, there has, by reason of anything done or left undone, there has, by reason of anything done or left what? Undone. And it's been a failure to comply with the rules, whether it is in respect of time. So you see, we are being told that if you fail to comply with the rules, and it is whether it is in respect of you not complying with the rules in respect of time, or you not complying with the rules in respect of place, you not complying with the rules in respect of manner, form or content, or in any other respect, the failure shall be treated as an irregularity and shall not nullify the proceedings, any step taken in the proceedings, or any document or judgment or order in it. It shall be treated as an irregularity and shall not nullify the proceedings, any step taken in the proceedings, or any document, judgment or order in it. So we've been told that under Order 81, under our current rules, whenever there's a non-compliance with the rules, whether it is in respect of time, whether it is in respect of place, whether it is in respect of manner, form or content, it shall be an irregularity and it shall not nullify the proceedings. What then is the difference between Order 81 of CI 47 and the old rules? Under the old rules, the court had the discretion to render the proceedings a nullity when there's a non-compliance with the rules. But under these rules, we've not given the court the discretion to render the proceedings void when there's a non-compliance with the rules. For those who have forgotten, take a look at the Order 70 of the LN 140A. That old rule says that non-compliance with any of these rules, or with any rule of practice for the time being enforced, shall not render the proceedings void unless the court or a judge shall so direct. It means that under the old rules, the judge has the discretion to direct that the proceedings shall be void. What do we have under the new rules? The new rules, it does not give the court the discretion to render any proceedings a nullity when there's a non-compliance with the rules. Because what does it say? Where, in the beginning, or purporting to begin, any proceedings, or at any stage in the course of, or in connection with any proceedings, there has, by reason of anything done or left undone, been a failure to comply with the requirements of these rules, whether in respect of time, place, manner, form or content, the failure shall be treated as an irregularity and shall not nullify the proceedings, any step taken in the proceedings, or any judgment, document or order in it. So under our current dispensation, under Order 81 of CI 47, 2004, we are told that the court has not been given the permission to declare proceedings as null and void merely because of a non-compliance with the CI 47. In our current dispensation, there's nothing like a breach which goes to the root of the trial, and a breach which doesn't go to the root of the trial. If you remember what Taylor G. said in Amoakoh and Hansen, where he was saying that there was a breach that goes to the root of the trial. In our current dispensation, we don't have any breach that goes to the root of the trial, and the one doesn't go to the root. Once there's a non-compliance with the rules, it shall not render the proceedings a nullity. Again, under our new dispensation, there's no non-compliance that will be deemed to be so fundamental, or a non-compliance with the rules that will not be fundamental. So under Order 81, all breaches or non-compliance with the rules are curable under Order 81. Order 81 is there to wash away every sin you commit when you are referring to non-compliance with the rules. So under Order 81 right now, the High Court has the power to save proceedings by amendment. Under CI 47, the judge cannot render proceedings a nullity due to a non-compliance. What the judge has the discretion to do is to set aside that proceeding that the judge can find as irregular due to the non-compliance. You can set aside that proceeding, but you can't declare everything a nullity due to the non-compliance. So take note, under Order 81 of CI 47, whenever there's a non-compliance with the rules, it will be treated as an irregularity that can be cured by the rules, and it shall not render the proceedings a nullity. So now when there's a non-compliance with our rules, it shall be treated as an irregularity, and that irregularity can be cured by the rules. But there's one point that I want to emphasize. Remember that I've always been mentioning that when there's a non-compliance with our rules, it shall render the proceedings a nullity. It shall render the proceedings an irregularity, and not a nullity. So when there's a non-compliance with Order 81, it shall render the proceedings, it shall be an irregularity and not a nullity. So it's an irregularity, it can be cured by the rules. I need to draw a distinction between when we say something is a nullity and when we say something is irregular. If it's a nullity, that's one, nothing can be done about it. For example, if a court gives a decision that it didn't have jurisdiction to give, then the whole decision is a nullity. That one, you can't talk about curing or not curing it. It is a nullity. So that one, if we bring it to your attention, you yourself, you must have it set aside. Because, for example, I've given an example in the beginning, that the High Court is the only court that has jurisdiction to enforce fundamental human rights under Article 33 of the Constitution. The High Court has exclusive original jurisdiction when you're enforcing fundamental human rights affecting a particular person. Article 33. So if I bring an action in, let's say, the circuit court, and then you, the circuit court, you go and enforce fundamental human rights under Article 33, you should know what you've done. It's a nullity. This is not mere irregular. It is a nullity. So I want to explain what you mean by a nullity and what you mean by something that is irregular. And the case of Musi and Bejina, reported in 1963, one Ghana law reports at page 337, will be very helpful. Akufo-Addo JSC, as he then was, said as follows at page 342. When a court or a judge gives a judgment or makes an order which it has no jurisdiction to give or make, or which is irregular, because it is not warranted by any enactment or rule of procedure, such a judgment or order is void, and the court has an inherent jurisdiction, either suo motu on the application of the party affected, to set the judgment or order aside. So if any proceeding in the High Court right now is a nullity, for example, the High Court goes to give a decision which it doesn't have the jurisdiction to enforce. For example, you go and enforce the Constitution, which is reserved for the Supreme Court under Article 2 and Article 130. When it is brought to your attention, please, you should know that it's a nullity, and the High Court can suo motu on the application of another party, set same aside. But where the proceeding is one which is irregular or invalid, then that proceeding shall be valid, shall continue until the affected party brings the application to set only that proceeding aside. In other words, under the 81 of the CI 47, every non-compliance with the rules, we shall treat it as an irregularity. And then, if we treat it as an irregularity, it shall continue. The proceedings shall continue, and it shall not nullify the proceedings. And then, the effect is that if you think you have been affected, you can bring an application to only have that proceeding alone set aside. But you can't say that everything should be a nullity. So if you look at the 81 sub-rule 2 of the CI 47, it tells us the consequence of failing to comply with the rules. It says that the court may, on the ground that there has been the failure, as stated in sub-rule 1, that is, there has been the failure to comply with the rules, the court on such terms as to cost, or otherwise as it considers just, shall set aside either wholly or in part the proceedings in which the failure occurred, any step taken in those proceedings, or any document, judgment, or order therein. Or it may even exercise its powers under these rules to allow such amendments to be made and make such an order dealing with the proceedings generally as is considered just. This is a saving grace for non-compliance with the rules. It is saying that now if you fail to comply with the rules, the High Court on such terms as to costs. So you can say that, well, you didn't comply with the rules by doing this, but you know what? I'm going to only award cost against you so that the case will proceed. Or you were supposed to have done this before doing this, you didn't do it, so I'm going to give you leave to go and amend it, and then award cost against you. Or it can also just set aside that proceeding alone, go and correct it, and let the case proceed. So if you can see, there is an attitude from Order 81 that when there's a non-compliance with the rules, the court is given the power to save the whole proceedings from collapsing. Look at the days of Azinogo and Augustt, where there was no compliance with the rules about time. You were supposed to give 4 clear days, and everything in the case became a nullity. Look at the case of Amoakoh and Hansen, failing to apply for directions. Said everything, even though they are giving judgment, everything, if he has taken 10 years, everything will be a nullity. Now the court is being given the permission that they can save, or they can only award costs, or they can allow some amendments, and that the failure to comply with the rules will not render the proceedings a nullity. So the implication of Order 81 is that an applicant who has realized that there has been a non-compliance with the rules, you cannot apply and say that you want everything to be set aside as null and void because of the non-compliance. You can't go and exhume the ghosts of Amoakoh and Hansen and say that in Amoakoh and Hansen we failed to apply for directions and so everything should be rendered a nullity, because it will be a non-compliance with the rules, and the rules say that it shall be an irregularity and it shall not render the proceedings a nullity. Now, as a matter of fact, even if there has been a non-compliance with the rules, the applicant, you have the right to bring an application to have that proceeding that was filed set aside. But you must even bring the application within a reasonable time. And you must not have taken a first step after the irregularity. Let me explain this. Under Order 207 sub 5 of the CI 47, if you want to sue somebody who is resident out of the jurisdiction, under Order 207 sub 5, you must seek leave of the court before the issuance of the writ of summons, notice of which is to be served out of the jurisdiction. That is what the rules require. This is a very critical rule that goes to the very beginning of the action. You must seek leave before the writ of summons will be issued. Let's say you didn't seek the leave and you issued the writ, but you served the notice of the writ out of the jurisdiction according to Order 8. Remember, there are 2 leaves you must seek. Because under the 207 sub 5, you must seek leave of the court for the issuance of the writ, notice of which is to be served out of the jurisdiction. You didn't seek that leave, but you only want to seek leave to serve the notice of the writ out of the jurisdiction. It means there has been a non-compliance with the rules in the beginning of the action. Then, even when it was served on you, you realize that there has been a non-compliance with the rules because they didn't seek leave of the court before issuing the writ, but you entered appearance, you filed your defense, they filed their reply, they applied for directions, witness statement has been filed, trial has been held, judgment has been given. Then now you want to bring an application to say that there was a non-compliance with the rules at the beginning of the action. And it is so fundamental because it's something that affected the case from the very beginning. Order 81 is saying that that was a non-compliance with the rules. And it should be an irregularity, and it should render the proceedings a nullity. And you have the right to bring an application under Order 81 Rule 2 to set that proceeding aside. You have the right to bring it. But you must act within a reasonable time, and you must not have taken any first step. In this case, when you saw the irregularity, you have filed your appearance, you filed your defense, you entered the box to give evidence. Now that the judgment is against you, you want to say that you want to nullify the proceedings. We will not allow you. We will not allow you, because today, under 81, non-compliance with the rules will be treated as an irregularity, and it shall not render the proceedings as void. So today, under 81, in the event of a non-compliance with the CI 47, the affected party must immediately bring the notice to the attention of the court. And then the court can set aside only that proceeding. But when you take a fresh step, and then you proceed nonetheless to the end, you can't come back and now complain. Look at the case of Amoakoh and Hansen. Amoakoh and Hansen, they failed to take the summons, but the case proceeded all the way to the end and judgment was given. Now that has gone against you, you are saying that because they failed to apply for directions, everything should be rendered a nullity. You succeeded in those days, but today, under 81, you may not be lucky. Because under 81, you are being told that even if there's a non-compliance with the rules, you must bring an application timeously to have that proceeding set aside. And you must not have taken the first step. If you take a first step, that irregularity will not nullify the whole proceedings. Look at what happened to Amoakoh and Hansen. He failed to apply for directions, but the case has transferred all the way to the end. That means, look at how cases travel in this country. Sometimes you can go to court and the case will travel for about 15 years. Then you come and tell me that because you failed to apply for directions, everything should be a nullity. That happened under LN 140. Order 81 is saying that any non-compliance with the rules will be an irregularity. And if you take a first step, you can't come back and complain anymore. So now today, any non-compliance with the rules will be an irregularity, and it can be cured by Order 81. And I really want to demonstrate how this occurred in the case of Ankuma. There's a case of Ankuma, Ankuma City. Ankuma is spelled Ankumah. Ankuma versus City Investment Company Limited. Ankuma is spelled Ankumah versus City Investment Company Limited. It's reported in 2007-2008 to Supreme Court of Ghana Law Reports at page 970. At page 970. In this case, there were no application for directions. No application for directions too were taken in this case, and the issue came up about whether it should render the proceedings a nullity or not. So in this case, what did the court say? The court delivered itself as follows, and I read, and I'm quoting from the case. It says that in any event, this court, and I refer to the Supreme Court, this court had the opportunity in the case of Anthony Kodobuachi versus Nana Tutuine, unreported Court of Appeal, J4-24-2006, dated 30th May 2007, to consider the effect of non-compliance of Order 30 on the trial. Order 30 on the trial. And they're referring to the Order 30 that also dealt with failing to apply for directions. If you remember, in Amoakoh and Hansen, it was the same Order 30. Order 30 that they failed to apply for directions. They applied for the summons for directions. That same Order 30 was not complied with. And they rendered the whole proceedings a nullity. Supreme Court of Ghana is saying that in any event, this court recently had the opportunity in the case of Buachi and Tutuine to consider the effect of a non-compliance with Order 30 on the trial. In the course of the judgment, the court considered the ratio of another Court of Appeal decision on Order 30 entitled Omani and Others versus Poku, which was at variance with the ratio in the Amoakoh case Supra. Apalu J, as it then was, in delivering the judgment of the court in the Omani case Supra, held at page 71 that the real question in this case is whether failure to settle issues formally in the summons for directions before their determination is such a fundamental defect as would vitiate the entire proceedings. I think not. Whereas in this case, the issues are clear, both on the pleadings and in evidence, the failure to set them out in the summons for directions, in accordance with Order 30, Rule 1 and 2 of LN 140, is a mere irregularity, which is curable under Order 70. I think, therefore, that this ground of appeal fails. This was Apalu in the case of Omani and Others versus Poku. So even in Omani and Others versus Poku, Apalu had already taken the view that failure to apply for directions will not render the proceedings a nullity. But this is, I want us to see what the court is saying in Ankuma versus City Investments Company Limited. And I'm reading as follows. This court, per Chum JSC, that Amoakoh and Hansen case itself was given per incuriam. This court held, per Chum JSC, that the Amoakoh and Hansen case itself was given per incuriam, as the Omani and Poco case was earlier in time, and the Court of Appeal was bound by its earlier decision on questions of law. So you see, in this case, you have been told that this Amoakoh and Hansen case that have been held as failing to apply for directions will render the nullity. They are saying that that case was even wrongly decided. So they've already held that they are not blasting Amoakoh and Hansen. That it was wrongly decided. I'm still reading from Ankuma versus City Investments Company Limited. And what I want you to have at the back of mind is the failure of not complying with the rules in applying for directions. In this case of Ankuma versus City Company Limited, Ankuma, A-N-K-U-M-A-H, versus City Investments Company Limited, Chum JSC went on to say as follows, and I quote, "This court is not bound by any decision of the Court of Appeal. I have carefully considered both the case of Omani versus Poku and Amoakoh and Hansen, and in my view, the Omani case reflects the rationale behind Order 30. I will therefore overrule the Amoakoh and Hansen case on the issue of the effects of a court settling the issues for trial." Now, Amoakoh and Hansen has been overruled. Amoakoh and Hansen is the case that in which we are told that if you fail to apply for directions, it is a serious fatality that will render the whole proceedings void. Now, it has been overruled. We are going ahead. And I'm still reading from Ankuma versus City Investment Company Limited. Ankuma versus City Investment Company Limited, reported in 2007, 2008, 2 Supreme Court of Ghana law reports at page 970. This is what Chum JSC said, and I continue. It follows that the decision of the Court of Appeal is disavowed and set aside. As I pointed out above, the entire Order 30 was a case management provision intended to ensure a smooth and expeditious progression of the suits. Other pleadings are deemed to be closed. It was not intended to abort the proceedings. The application of the so-called Mosi and Bejina principle by the court was seriously flawed. Fortunately, Order 30 does not exist in the pristine form in the new High Court Civil Procedure Rules 2004 CI47. Further, the new Order 81 has made it clear that perhaps, apart from lack of jurisdiction, in this true and strict sense, any other wrong step taken in any legal suit should not have the effect of nullifying the judgments or the proceedings. This means that the Mosi and Bejina principle has been rendered otiose. I'll read this final portion again. Further, the new Order 81, which has made this clear that perhaps, apart from lack of jurisdiction, in its true and strict sense, any other wrong step taken in any legal suit should not have the effect of nullifying the judgment or the proceedings. It means that today, apart from lack of jurisdiction, that if the High Court doesn't have jurisdiction and it entertains a case, that one you can set aside. It says that apart from lack of jurisdiction, any wrong step taken in any legal suit should not have the effect of nullifying the judgment or the proceedings. This means that the Mosi and Bejina principle has been rendered otiose. Let me read the final words of Chum JSC. It says as follows. To conclude, and I'm still reading, and I'm still referring to the case of Ankuma versus City Investment Company Limited, reported in 2007, 2008, 2 Supreme Court of Ghana law reports at page 970. To conclude, and these are the words of Chum JSC, I quite agree with the reasoning of Apalu in the Omani case at page 71 of the judgment that the real question in this case is whether failure to settle issues formally in the summons for directions before their determination is such a fundamental defect as would vitiate the entire proceedings. I think not. Whereas in this case the issues are clear, both on the pleadings and in evidence. The failure to set them out in the summons for directions in accordance with Order 30, Rule 1 and 2 of LA 140, is a mere irregularity which is curable under Order 70. I think therefore this is ground of appeal fails. I also agree with him that the court should not really treat a defect as fundamental and so a nullity, and should rather be anxious to bring the matter within the umbrella of Order 70 when justice can be done as a matter of discretion. So he was quoting the words of Apalu in Omani and Puku. So this is how Chum JSC in this case of Ankuma versus City Investments Company Limited proceeds. And this statement is about to make is so important in your understanding of Order 81. And I'm referring to Ankuma versus City Investments Company Limited. This is what Chum JSC says, and I quote. Fortunately, if I may say, the President Order 81 captured the spirit of this view. To borrow some of the words of Dr. JSC in the August case Supra, this new Order 81 has removed the helplessness of judges in the face of procedural nullities. You see what Dr. Chum JSC is saying? Fortunately, if I must say, the President's Order 81 captured the spirit of this view. To borrow some of the words of Dr. JSC in the August case Supra, this new Order 81 has removed the helplessness of the judges in the face of procedural nullities. So that in time past when the judges did not have a choice but to treat things as a nullity, like we saw in Amoakoh and Hansen, that when you fail to apply for directions, they say that it should be a nullity, as Taylor GSC would say. As we also saw in the cases of Azinogo and Augustt, when they are supposed to have given 2 clear days, they did 4 clear days, and they gave only 2 clear days, it was treated as a nullity. It says that this Order 81 has removed the helplessness of judges in the face of procedural nullities. Now today, if you fail to comply with the rules here 47, the court has the power to treat that non-compliance as a mere irregularity that will not nullify the proceedings. So you remember that in Amoakoh and Hansen, non-compliance with the rules, failing to apply for directions, render the whole proceedings a nullity. Now we've seen in Ankuma versus City Investments Company Limited that today if you fail to apply for directions, it will not render the proceedings a nullity. And we have even been told that that same position too has been taken in the case of Boache and Tutu Yene. Same position has been taken inside. That if you fail to apply for directions, it will not render the proceedings a nullity. So, the final words of Dr. Chum JSC in Ankuma versus City Investment Company Limited, reported in 2007, 2008, 2 Supreme Court of Ghana Law Reports at page 970. This is what he says. For above reasons, I hold that the Court of Appeal erred in holding that the proceedings by the trial court in the absence of setting down the issues in the summons filed by the appellant and additional issues filed by the respondent was a nullity. The failure to take summons for directions that had been filed and served on the respondent do not vitiate the trial. In any event, the issues were clear upon the pleadings and the issues filed by the parties themselves. It was the duty for the counsel of the respondent who had counterclaimed to see to it that summons was taken. The failure is a mere irregularity and does not go to the root of the jurisdiction of the court to hear the case on the merits. Full stop. So what I want you to see over here is that we have moved from the days of Azinogo and August. You remember Azinogo and August? In Azinogo and August, they are supposed to give 4 clear days. They gave 2 clear days. The court held that non-compliance with time rendered the whole proceedings a nullity. Amoakoh and Hansen, you saw what happened there, failing to apply for directions, rendered the whole proceedings a nullity. Now we have seen that we moved away from the spirit of Amoakoh and Hansen. We even have Boache and Tutu Yene. We also have Ankuma versus City Investments Company Limited, which has taken the position that if you fail to apply for directions, it will not render the proceedings a nullity. So the spirit of Amoakoh and Hansen has been buried. We have given Amoakoh and Hansen a decent burial. If you fail to apply for directions, it's going to be a mere non-compliance with the rules, and it will not render the proceedings a nullity. That's what Dr. Chung GSC is saying in Ankuma versus City Investment Company Limited. Ankuma versus City Investment Company Limited, reported in 2007-2008. Two Supreme Court of Ghana law report at page 970. So, at this point, you remember Azinogo and Augustt. You remember also the case of Amoakoh and Hansen. And you have seen that we move from Amoakoh and Hansen. By another case that begins with A, Ankuma versus City Investment Company Limited, says that if you fail to apply for directions, it will not vitiate the trial. It will be a mere irregularity that can be cured by Order 81. But I have another question to ask. Assuming that case of Azinogo and Augustt comes before the court again today, what do you think the conclusion will be? Because under our new CR 47.2, we have under Order 14, application for directions. So what I want to find out is that we also have under our new rules, summary judgments. So what I want to find out is this. Assuming under our new rules, summary judgment on Order 14, in fact, that is the position there. You must still give 4 clear days before you hear the application for summary judgment. So if I file my application for summary judgment and I serve you on the 1st of January, I must make sure we have 4 clear days before I go and move my application for summary judgment. But let us say that I serve you on the 1st of January. And the return date is the 3rd of January. You don't show up in court and I go and move my application. Can you come to the court and say that there has been a non-compliance with time? And so everything should be treated as a nullity because you were served on the 1st. You saw that it was 3rd, but you refused to come because by the rules, you are saying that you are supposed to be given 4 clear days. If you fail to show up and judgment is given against you, can you appear before the judge and say, my lord, on Order 14, before an application for summary judgment is moved, there must be 4 clear days between the time I was served and the time the application was moved. Well, from the fact I was served on 1st January and they moved it on the 3rd. And so, my lord, I'm relying on the case of Azinogo and Augustt when a similar thing happened, that everything should be treated as a nullity. In that same case, you come before the court today. What do you think the conclusion of the court will be? Would they say that a failure to comply with time will render the proceedings a nullity? Or it will render it a nullity? What do you think? Because by the rules, you are supposed to be given 4 days at least so that you can have enough time to prepare. You were served on the 1st, you refused to go. And they heard it on the 3rd, and they've given judgment. Just like what happened in Azinogo and Augustt. If similar facts come before our court today, what would the court say? I want you to know that those were similar fact patterns that we had in the case of Republic versus High Court, ex parte August Limited. Republic versus High Court, Accra, ex parte August Company Limited, Amalgamated Bank, interested party, reported in 2007-2008, Supreme Court of Ghana Law reports at page 1041. This is what transpired in that particular case. And I'm reading the words of Datiban GSC in that case. A bank, the second respondent, brought action against the applicant in this case, and 2 others to recover a debt owed it. After the defendant had been served with the writs and they had entered appearance, the bank filed a motion for summary judgment against them on 6 December 2007. The motion was fixed for hearing on 18 December 2007, and the applicant was served with it on Wednesday, 12 December 2007. Let me pause here and do a demonstration. The motion So the bank filed a motion for summary judgment against them on the 6th of December. So that is the date of filing. The motion was fixed for hearing on the 18th of December. That was the return date on the application, 18th December. But the applicant was served on Wednesday, 12th of December. Now, on the 18th of December, the bank moved its motion in the absence of the applicant hearing. The trial high court, the first respondent in this case, granted application on 28 February 2008 and entered judgment in favor of the bank. The applicant's complaint is that the bank did not comply with the mandatory rule of procedure that there should be 4 clear days between the date of service of the motion for summary judgment and the return date. It was contended that since the applicant was served on Wednesday, 12th of December, the 4th clear day was the 18th of December, and that the application should not have been moved on that date. Now, whenever I teach this topic, there are a number of students who will ask and say it as well, but they were served on the 12th of December. And then the 4th clear day would mean that it's supposed to be the 16th of December. So if they, even if you start counting from 13th, it's going to be 17th of December. So they could have moved it on the 18th. But that's not the complication. I want you to understand this well. So take note that the Wednesday that they were served was the 12th. That was a Wednesday. So if you want to count 4 clear days, you start counting from Thursday. So Thursday is one day. That'll be the 13th. Then Friday will be the 2nd day. That'll be the 14th. Now, Saturday, Sunday, which is the 15th, 16th, we don't count it because it's a weekend. So, you come to 17. That'll be the 3rd clear day. Then the 18th, which will be the Tuesday, would be the 4th clear day. So, there ought to have been 4 clear days. So if they could have moved the application at all, it ought to have moved rather on the next Wednesday. But they rather went to move it on the Tuesday, which was on the exact day. That was the 4th day. So I'm proceeding to read the words of Dr. Ban GSC. So it was contended that since the applicant was served on Wednesday, 12 December, the 4th clear day was 18 December 2007, and that the application should not have been moved on that date. It was his case that the consequence of the application having been moved on 18 December was that it rendered the proceedings based on its null and void. He therefore argues that the judgment of 28 February 2008 is null and void and should be set aside. Though the second respondent bank admitted that the return date on this motion was 18 December, it contended that on that day the case had been adjourned to enable the applicant to be given more time before moving the hearing of the application. The second respondent, however, admitted that he moved its application on 18 December before the trial judge adjourned the case sine die and directed a hearing notice be served on the applicant. On these facts, there have been short service. What this court has to consider are the legal consequences of such short service. To summarize then, when there has been non-compliance with any of the rules contained in the High Court Civil Procedure Rules 2004 CI 47, such non-compliance is to be regarded as an irregularity that does not result in nullity. Unless the non-compliance is also a breach of the Constitution or of a statute, other than the rules of courts or the rules of natural justice, or otherwise goes to jurisdiction. I'll read that portion again. And please take note of this portion. It's one of the most important places in this case of Republic versus High Court Accra ex parte August. To summarize then, when there has been non-compliance with any of the rules contained in the High Court Civil Procedure Rules 2004, CI 47, such non-compliance is to be regarded as an irregularity that does not result in nullity. Unless the non-compliance is also a breach of the Constitution, or of a statute, or the rules of natural justice, or goes to jurisdiction. The reason I want you to take note of this portion is this. This case is telling you that if there's any non-compliance with the CI 47, it is supposed to be treated as an irregularity, but there are some exceptions. And the exceptions are that when there's a non-compliance with a constitutional provision, that one, it cannot be cured. When there's a non-compliance with the statutes, like an act of parliament, apart from the CI 47, if there's a non-compliance with the statutes, it cannot be cured. If there's a non-compliance with natural justice, it cannot be cured. Or if it's a non-compliance that goes to jurisdiction, it cannot be cured. So from this case, you have 4 exceptions to Order 8.1, and I want you to take note of it. I'll read that portion again. To summarize then, when there has been non-compliance with any of the rules contained in the High Court Civil Procedure Rules 2004, such non-compliance is to be regarded as an irregularity that does not result in nullity. It means that whenever there's a non-compliance with the rules, it's supposed to be an irregularity. That will not be a nullity unless the non-compliance is also a breach of the Constitution, 1, or of a statute, number 2, or a breach of natural justice, number 3, or goes to jurisdiction, number 4. So there are 4 exceptions. If it's a non-compliance with the rules alone, it can be cured. But if it's a non-compliance with the Constitution, 1, or non-compliance with the statutes, number 2, or non-compliance with natural justice, number 3, or non-compliance with goes to jurisdiction, number 4, those ones cannot be cured. I proceed to read the words of the justice. The critical issue in this case then is whether the non-compliance complained of on the facts of the case goes to jurisdiction or is a mere irregularity. Applying the law as stated above, following the coming into force of the High Court Civil Procedure Rules 2004, it is clear that the holding by Ampere J.A., as he then was, in Azinogo versus Augustt and Company Limited, 1989-1990, 2 Ghana Law Report at page 278, that short service in a default procedure resulted in nullity of the subsequent proceedings can no longer be supported. I'm taking that part again. Applying the law as restated above, following the coming into force of the High Court Civil Procedure Rules 2004, it is clear that the holding by Ampere J.A. as he then was in Azinogo and Augustt, Company Limited, reported in 1989-1990, 2 Ghana Law Report at page 278, that short service in a default procedure resulted in the nullity of the subsequent proceedings can no longer be supported. The short service is to be regarded as an irregularity which does not cause an automatic nullity. This conclusion is fatal to the applicant's case. Without the default judgment being a nullity, a certiorari does not lie to quash it. End of quote. What do we see from this case? Similar facts from what we had in Azinogo and Augustt. In Azinogo and Augustt, you remember that in that case too, they had applied for summary judgment. They were supposed to give 4 clear days. It was just about 2 days. And the court held that the failure to comply with the rules by not giving the 4 clear days resulted in the whole proceedings in the judgment being a nullity. You remember, Azinogo and Augustt. Today we are seeing in this case of Republic versus High Court Accra, ex parte August, that the short service, that is failure to comply with the time, will not result in the proceedings being treated as a nullity. And therefore the judgment still stood as a valid judgment in ex parte August. So I believe by now you can see the change in judicial attitude from pre-CI 47 to post-CI 47. Before CI 47, we saw the case of Amoakoh and Hansen, where the court held that failing to apply for directions will render the whole proceedings a nullity. We have seen how that has been given a decent burial by Boachi and Tutuyini, and also the case of Ankuma versus City Investment Company Limited. So in Boachi and Tutuyini, in Ankuma versus City and Company Limited, we are told that if you fail to apply for directions, it will not render the proceedings a nullity. So that gives the case of Amoakoh and Hansen a decent burial. And Amoakoh and Hansen was before CI 47. And these cases, Boakye to 2 in this case of Ankuma versus City and Company Limited, these ones were after CI 47. So now if you fail to apply for directions, Ankuma versus City and Company Limited, we are told that it will, City and Investment Company Limited, it will not result in a nullity. Then we come to this case of Azinogo and Augustt, which was in 1989 under the old rules, when the court held short service. Short service was treated as an irregularity, as a nullity. That rendered the whole proceedings void. Today we are seeing in Republic versus the High Court Accra, as part the August, that short service will not render the proceedings a nullity. So now at least we are quite certain that short service, that is not complying with the rules that says that in respect of time, they must give 4 clear days. Non-compliance with respect of time will not render the proceedings a nullity. I don't know whether at this point something is ringing a bell. If you remember Order 81, it says, when there has been anything left undone, being a failure to comply with these rules in respect of time, it shall be treated as an irregularity. So I'm not surprised as Party August is having this decision. Because the rule says you must give the person 4 clear days, and you gave him about 3 days. That is a non-compliance with respect to time, and the rule says that it shall be treated as an irregularity. So at this point, let us just do a recap to this point where we've gotten to. We started from the old rules, LN 140. Under LN 140, there were some categories of non-compliance that can render the proceedings a nullity, and others that cannot render the proceedings a nullity. Under LN 140, we had the case of Amoakoh and Hansen, where we are told that failing to apply for directions will render the proceedings a nullity. We saw Azinogo and August, where we are told that short service rendered the whole proceedings a nullity. Under 81 says that if you fail to comply with the rules with respect to time, form, manner, content, it will render the proceedings a nullity. So what are the cases that we have under 81? We have the case of ex parte August, which is a direct opposite to Azinogo and August. Because in ex parte August, we have been told that short service will not result in the proceedings being a nullity. Another case after order 81 is the case of Boakye and Tutuyini and Ankuma versus City and Country Company Limited. City and Investment Company Limited. We are told in that case as well that in that case too, failing to apply for directions, Boakye and Tutuyini is telling us that failing to apply for directions will not render the proceedings a nullity because it's a non-compliance with the rules. Let us look at another case in which there was a non-compliance with the rules. And let me give you a background. This case I'm about to go to is a case in which, if you remember, I gave an example under Order 277-5 that before you commence an action against a person who is resident out of the jurisdiction, you must seek leave of the court for the issuance of the writ, notice of which is to be served out of the jurisdiction. In this case, those provisions were not complied with. Let us see how the Supreme Court would deal with it. Would they say it is a non-compliance that will go to the roots and render the whole proceedings void? Because I have heard people argue that way, that you see, the rule says that you must seek leave before issuing the writ. So if you didn't seek the leave before issuing the writ, people have argued that then it goes to the very root of the case and everything should be a nullity. Let's see how the Supreme Court deals with it. In this case of Friesland, Friesland is spelled F-R-I-E-S. Friesland, Frico. Frico is F-R-I-C-O. Domo, D-O-M-O. Friesland, Frico Domo, Dachel Company Limited. It's reported in 2012. One Supreme Court of Ghana law reports at page 41. This is what happened in that case. Now in this case, it started by quoting Order 204 of LN 140, and they quote as follows. No writ of summons for service out of the jurisdiction, or of which notice is to be given out of the jurisdiction, shall be issued without leave of the court. They are quoting the rules that the writ shall not be issued without leave of the court. The defendant admits that the plaintiff did not comply with the rule of procedure, that an intended plaintiff must first obtain leave of the court before issuing a writ out of the jurisdiction. Similarly, the intended plaintiff must seek leave to serve notice of the writ out of the jurisdiction. He complained that the plaintiff filed a notice of a writ of summons to be served out of the jurisdiction, and he never obtained the mandatory leave as required by LN 140A. He argued that the jurisdiction of the High Court was therefore not properly invoked, and as a result, the writ of summons and the whole proceedings based on it are null and void. Let me pause and explain this before I proceed. He's saying that this is a leave you must seek before issuing the writ, and it is the issuance of the writ that invokes the court's jurisdiction. He's saying that since you didn't seek the leave before issuing the writ, it means that there was something fundamentally wrong at the time you were even giving birth to the whole case. He's saying that it renders the whole case incurably defective. He says it renders the case moribund, that it makes it dead on arrival. That from the very beginning when you were planting the case, you were supposed to have sought leave to even plant it. You didn't seek the leave. So from the very beginning, you have not even properly invoked the court's jurisdiction. That is the argument that is being made over here. That the rule says that you must seek leave before issuing the writ. And he didn't seek the leave. He's saying that it renders the whole proceedings null and void. Now, I'm still reading from Friesland, Frico Domo versus Dachau Company Limited. Reported in 2012, One Supreme Court of Ghana Law Reports at page 41. It says as follows, and I quote, "We note that Order 81 of the High Court Civil Procedure Rules 2004 CI 47 and the extinct Order 70 of LN 140 both provide in clear terms that non-compliance with the rules of procedure shall not render any proceedings void, but be regarded as a mere irregularity which might be allowed, amended, or set aside on terms at the discretion of the court upon an application brought within a reasonable time, and the person applying has not taken a fresh step after becoming aware of the irregularity." Again, we note that Order 81 of CI 47 and the extent Order 70 of LN 140 both provide in clear terms that non-compliance with the rules shall not render any proceedings void, but be regarded as a mere irregularity which might be allowed, amended, or set aside on terms at the discretion of the court upon an application brought within a reasonable time, and the person applying has not taken a first step after becoming aware of the irregularity. And they refer us to the case of Republic vs. High Court Accra, as per the August Company Limited, for a detailed discussion on these two rules. And they proceed as follows. This court has since then taken a radical attitude to arguments claiming nullity in respect of procedural lapses. In Boachi and Tutuine, reported in 2007-2008, Supreme Court of Ghana Law Reports at page 970, as well as in Ankuma vs. City Investment Company Limited, reported in 2007-2008, Supreme Court of Ghana Law Reports at page 1065, failure to take summons for direction under Order 30 was held to be a mere irregularity and not vitiating the proceedings. In the Republic vs. High Court Accra, as per the August Company Limited, Amalgamated Bank Interested Party, Supra, the defendant applicant was short-served by 1 day with the hearing of an application for summary judgment, but failed to appear for the hearing. The High Court Accra went on and granted summary judgment. In an application by the defendant applicant for an order of certiorari to quash the ruling on the ground of non-compliance with the mandatory provision of Order 14 Rule 2, 3 of CI 47, which requires the defendant to be served with notice for 4 clear days before hearing of the application for summary judgment. This court, in dismissing the application, held with that demand GSC at page 1053 that, and I quote, "Non-service of a process where service of same is required, in my view, goes to jurisdiction. Non-service implies that all the or term party, the rule of natural justice, is breached. This is fundamental and goes to jurisdiction. Thus, the reason why even after coming into force of Order 81 of our rules, non-service of the process results in the nullity is not because of non-compliance with the rule of procedure, but rather because it's an infringement of a fundamental principle of natural justice as recognized by the common law. This court, in dismissing the application held per Datiba GSC at page 1053, that similarly, breach of the principle of nemo judice in causa sua would result in a nullity. In contrast, short service need not be treated as fundamental enough to go to jurisdiction. It should thus be regarded as an irregularity that may serve as a ground for setting aside the proceedings following it, but it does not make the proceedings null and void. In the Republic vs. High Court, Koforidua expert Ankuma also reported in 2009 Supreme Court of Ghana Law Report at page 141. The High Court, in breach of Order 25 Rule 91 and Sub Rule 2, failed to order the successful party to give an undertaking to damages in a contested application for interim injunction before granting the application. In an application for the order of certiorari to quash the decision of the High Court, this court held that even though the trial judge erred by not complying with the mandatory rule of procedure as specified under Order 25 Rule 9 Sub Rule 1 and Sub Rule 2, before making the order, the non-compliance was a mere irregularity that was curable under Order 81. I'll take that portion again. In the Republic vs. the High Court, Koforidua expert Ankuma 2009 Supreme Court of Ghana Law reports the High Court, in breach of Order 25 Rule 9 Sub Rule 1 and Sub Rule 2, failed to order the successful party to give an undertaking to damages in a contested application for interim injunction before granting the application. In an application for the order of certiorari to quash the decision of the High Court, this court held that even though the trial judge erred by not complying with the mandatory rule of procedure as specified by Order 25 Rule 9 Sub Rule 1 and Sub Rule 2 of CI 47, before making the order, the non-compliance was a mere irregularity that was curable under Order 81. In summary, the non-compliance with the rules of procedure or any existing practice is a mere irregularity that does not automatically render proceedings following the non-compliance void. Again, in summary, non-compliance with the rules of procedure or any existing practice is a mere irregularity that does not render the proceedings following the non-compliance void. A party who becomes aware of the non-compliance is at liberty to bring an application to the courts and have the proceedings set aside. The rules require that no application to set aside any proceedings for irregularity shall be allowed unless it is made within a reasonable time, and the party applying has not taken any first step after knowledge of the irregularity. The Court of Appeal held that counsel received service of the writ in Ghana and fully participated in the proceedings till judgment, and so the defendant can be said to have waived his objection to the jurisdiction of the courts. Let me comment on this part before I proceed. You remember Order 81 Sub Rule 2 says that when you become aware of the irregularity, you can bring an application to have it set aside. But you are not supposed to take a first step. In this case, you are aware of the irregularity. You have participated in the proceedings all the way to the end, and you now want to complain. The case goes ahead. The Court of Appeal held that the counsel received service of the writ in Ghana and fully participated in the proceedings till judgment, and so the defendant can be said to have waived his objection to the jurisdiction of the court. The defendant submits that the above findings were wrong as the writ was served on the defendant in Holland, and the brief referred to counsel by defendant solicitors in England. Counsel claimed he only realized the breach after he received the record of appeal. We are taken aback by this statement as the address or service of the writ or that of Holland, where the defendant was served. In the circumstances, it is reasonable to expect that the first and primary duty of any astute lawyer who received a brief from a client domiciled abroad was to ascertain and be satisfied that the rules regarding service out of the jurisdiction has been complied with before taking any further step aside from entering appearance. Such information could easily be obtained by simply filing a search in the High Court registry. We regret to say that counsel was indolent and failed to exercise due diligence in the matter. We do not think counsel's failure to discover the non-compliance in time should render the whole proceedings in which the defendant actively participated and pursued a counterclaim a nullity. We consider the objection at this time trifle and highly unreasonable, more so as the subject matter of the action begun by the writ falls within the jurisdiction of the courts, and that the then Order 70 of LN 140, as well as under Order 81 of CI 47, this court has the discretion to either set aside the proceedings or making any orders as it deems fit. Looking at the circumstances of the case, has received no evidence of disadvantage occasioned by the irregularity or erosion of natural justice. Accordingly, we do not think it is fit and just to set aside the whole proceedings for a mere irregularity. For these reasons, the appeal fails on this ground. It means that what we are getting from this particular position is that even the rule that requires that you must seek leave before issuing the writ of summons, notice of which is sent out of the jurisdiction, the people failed to comply with it and the defendant actively participated. The court said that non-compliance was a mere irregularity that will not vitiate the whole trial. So you see what is happening so far? It means that now there is a judicial attitude. If you look at the cases like Ankuma versus City and Investments Company Limited, where the court held that if you fail to apply for directions, it will not render the proceedings a nullity. If you look at the case of Boachi and Tutu Yene, where the court took the view that if you fail to apply for directions too, it will not render the proceedings a nullity. If you remember the case of ex parte August, where the court also took the view that if you fail to give the full service, you give short service, it will not render the proceedings a nullity. It means that now, when you fail to comply with the CI 47, it will be treated as a mere irregularity that can be cured by the rules. So in this case, all the argument made by the lawyer that this was a leave they ought to have sought before invoking the court's jurisdiction, it didn't hold sway. So I want you at this point to remember your cases very well. Remember what happened in Amoakoh and Hansen, where the court held that failing to apply for the directions, we render the proceedings a nullity. Remember also the cases, all the cases that we looked at in that particular regard. Remember the case also of Azinogo and Augustt, where short service was held to treat the whole proceedings as a nullity. They come to post Order 81, then begin with Boachi and Tutu Yene, and use Boachi and Tutu Yene to kill Amoakoh and Hansen. Because Amoakoh and Hansen say that if you fail to apply for directions, it renders a nullity. Use Boachi and Tutu Yene, and also use Ankuma versus City and Investment Company Limited to say that now, even if you don't apply for directions, it will render the proceedings a nullity. Then let's come to the next case of Azinogo and August. Short service was held to result in the whole proceedings being a nullity. And that one was pre-Order 81. So post-Order 81, then you use ex parte August to pass that one. Then the ex parte August, the court of the short service will be treated as an irregularity that will not nullify the whole proceedings. Then if you want extra cases, look at Friesland, Frico Domo versus Dachau Company Limited. In which case, we told that even if you seek leave, that you are required to issue a writ, notice of which is to be sent out to the jurisdiction. That one too is going to be a mere non-compliance, a mere irregularity that can be cured by Order 81. I'll wrap up my discussion in one case that has held to be stirred a number of emotions, academic emotions and intellectual emotions for some people in the legal faculty. Is the case of National Investment Bank Limited and others, number 1, versus Standard Offshore Trust Company Limited, number 1. Before I go into this case, please remember that from all the cases we look at so far, if you fail to comply with the rules the Supreme Court has held that it will be a mere irregularity that can be cured. Let us see what the court will hold in this case. Because in this case, it was about a non-compliance with Order 2 Rule 4 Sub Rule 2. If you look at Order 2 Rule 4 Sub Rule 2 of the CI 47, it says that if you are commencing an action on behalf of a person who is resident outside the jurisdiction, you must state the person's address on the face of the writ of summons. That wasn't complied with. So, of course, that will be a non-compliance with the rules. Let us see what the Supreme Court would say and how to treat that non-compliance. This is what the court held in holding 6 of the head notes. Failure to comply with the prerequisites for the issuance of a writ and Order 2, Rule 4 Sub Rule 2, rendered a writ void. Yes, I know a number of you will be surprised, because in all the cases we've seen so far, like Ankuma, the City and Investment Company Limited, like Esparte, August, like Friesland, Frico versus the Chow Company Limited, all of them say that if you fail to comply with the rules, it will be an irregularity that can be cured. We have this case of National Investment Bank Limited and others, number 1 versus Standard Bank Offshore Trust Company Limited. It says that failure to comply with the prerequisite for the issuance of a writ on Order 2 for Sub Rule 2 rendered a writ void, and it could neither be saved by an amendment nor waived by the court. Therefore, where a writ of summons issued by a foreign-based firm claimed to be suing on behalf of certain investors, but it became an essential ingredient or prerequisite for the plaintiff to disclose the persons on whose behalf it were issuing were. Additionally, where the certain investors were foreigners, that fact together with their addresses must be disclosed, and both must appear on the face of the writ of summons as endorsement, else the writ would be voided. In the instant case, since Finks and Frico were foreign-based companies and their foreign addresses were not disclosed on the endorsement of the writ, the prerequisites for the issuance of a writ of summons under Order 2 for Sub Rule 2 of CI 47 had not been met, and that non-compliance rendered the writ void. By being void, the writ could neither be perfected by a waiver under Order 81 nor by an amendment. Whenever I teach and I get to this point, we always have questions coming. Now, why is it that in Ankuma versus City and the Investment Company Limited, the Supreme Court took the view that failing to comply with the rules, by failing to apply for directions, even failing to apply for directions, would be cured by Order 81? In Boateng Tutu Yini, same, failing to apply for directions was held curable. In Esparte August, failing to comply with the rules about timelines was held to be curable. In Friesland Frico Company Limited versus Dachel, that one too, failing to even seek leave for the issuance of the writ was held to be non-compliance. That was curable. And now we have National Investment Bank Limited and others versus Standard Bank Offshore Trust Company Limited, saying that if you fail to state the address of a foreign entity on the writ, it makes the whole writ void, and it could neither be perfected by a waiver nor by an amendment. I would encourage you to read this case proceeded even on review. I encourage you to look for the review decision, read it, and read the dissenting opinion of Atuguba GSE in this particular case when they proceeded on review. But the review still affirmed the ordinary bench decision that if it's a foreign firm and you fail to state the address, it renders the whole proceedings a nullity, and it cannot be cured by an amendment. So, by way of recap, in terms of the consequence of not complying with the rules, what we can do is to say that right now, under Order 81, any non-compliance with the rules can have that proceeding set aside, especially if the party that is not in breach has not taken any first step after that non-compliance has come to his attention. But you can only have that proceeding set aside, but you can't render the whole proceedings a nullity. But even that one, even if you apply to have it set aside, the court had a discretion to say that what rules set aside will allow him to cure it by an amendment and will award you costs. There is a judicial attitude to save proceedings. when there's a non-compliance with the rules. So by way of summary so far, what we've done in this lecture is that we sought to deal with the effect of not complying with the rules laid down in the High Court Civil Procedure Rules. We mentioned from the beginning under order 1 that the rules under order 1 is supposed to apply to both the High Courts and also Circuit Court with the necessary modifications. So for the High Court, what are the implications if you fail to comply with the rules? We've looked at the rules that were applicable before Order 81. And we've seen the cases that were applied under the old rules. We've seen Amoakoh and Hansen, where the court held that if there's a non-compliance, that goes to the roots of the matter and to render the whole proceedings void, as we saw in Amoakoh and Hansen. In that case, failing to apply for directions render the whole proceedings and the judgment a nullity. We've seen Azinogo and Augustt, short service render the whole proceedings to a nullity. Then we come after under 81. What are the cases? Boachi and Tutu Yene, Ankuma versus City and Investment Company Limited. These cases took the view that even if you fail to apply for directions, it would indeed result in a situation where the whole proceedings can be saved. It should be treated as an irregularity, and it can be cured. An amendment or the court can save all the proceedings. Again, we saw ex parte August, where we were told that in that case, short service, because the application for summary judgment, you had to give the people 4 clear days. He went on the 3rd day. The court held that one too will be deemed to be a mere irregularity that will not render the proceedings a nullity. And then also, we saw Riceland Frico Company Limited versus Dachau Company Limited, where we're told that even if you fail to seek leave of the court before issuing a writ, notice of which is to be sent out of the jurisdiction, that one too will not render the proceedings a nullity. It will be a mere irregularity that can be cured by the rules. And then finally, we wrapped up with the case of Standard Offshore, National Investment Bank Limited versus Standard Bank Offshore Trust Company Limited, where we saw in this case that foreign entity failed to comply with the requirements of Order 2 Ruffosa Rule 2. The Supreme Court held that non-compliance rendered the whole proceedings a nullity, and it could not even be cured by an amendment. This is where we shall draw the curtains on this lecture with respect to non-compliance with the rules. That is, non-compliance with the High Court Civil Procedure Rules 2004 CI 47. Thank you.